06-1815 and 06-1853 Paul Fisher versus Emma Hasenjager. In this case, Justice Cupp has recused himself, and we're pleased to have sitting in place of Justice Cupp Judge Patricia Blackman, who is a judge of the Court of Appeals sitting in the 8th Appellate District. Welcome, Judge Blackman.
Thank you.
Mr. Dougherty.
Mr. Chief Justice, members of the court, Justice Blackman, may it please the court, my name is Douglas B. Dougherty. I'm here representing the appellant Paul Fisher. Mr. Fisher is with us today in the gallery, and I would like to reserve 3 minutes of my time for rebuttal. The basic question presented in this case is, does Revised Code 3109.04 E2B allow a court to modify residential parent and legal custodian status in a shared parenting case? In this case, context is critical. We already have another subsection, E1A, that allows a court to make such a modification. However, E1A contains a stricter test, a higher standard, if you will. Thus, the question becomes, did the legislature intend to enact a provision that grants the same power to a court, but that contains an easier test, or a lower standard? We believe that the answer to that question is no. 2 primary points support this conclusion, and these are the first 2 arguments in our merit brief. Point number 1, a court can only modify residential parent and legal custodian status under E1A. Basically, E1A says that a court can modify an allocation of parental rights and responsibilities. A designation as a residential parent and legal custodian is an allocation of parental rights and responsibilities. Thus, under E1A, a court has the power to modify residential parent and legal custodian status. Numerous courts of appeals have come to this conclusion. Further, no other statutory provision in the custody statute states that a court can modify residential parent and legal custodian status in a shared parenting case. Point 2, Section E2B does not authorize a court to modify residential parent and legal custodian status. The express language of E2B does not contain such an authorization. It is silent regarding residential parent and legal custodian status. It only says that a court can modify the terms of a shared parenting plan. Unfortunately, the statute does not define these words. Thus, at this point, another core question is raised. Is residential parent and legal custodian status a term of a shared parenting plan? The answer is no. Residential parent and legal custodian status is not a term of a plan. Rather, residential parent and legal custodian status is addressed in a shared parenting order. If we look at subsection A2 of the custody statute, it says that a court may grant a shared parenting order. Subsection K6 states that residential parent and legal custodian status is always addressed in a shared parenting order. Now, the language of that subsection is a little awkward, but basically it says 2 things. If the court issues a shared parenting order, and if that order is silent, then both parents are automatically designated as residential parent and legal custodian. The subsection also says that if a court desires, it can expressly address residential parent and legal custodian status as well. Thus, we see that residential parent and legal custodian status is addressed in a shared parenting order and not in a shared parenting plan. Other provisions of the custody statute also show the difference between a shared parenting order and a shared parenting plan. Various provisions show that an order and a plan have different functions. Basically, these show that an order is a general grant of authority, and hence it addresses residential parent and legal custodian status, while a plan contains the specific details on how that authority will be exercised. For example, the parenting time schedule, child support order, medical and dental care. An example of these provisions is subsection J. Subsection J defines shared parenting, and it says that shared parenting means parents share in the care of their children, and now I quote, in the manner set forth in the plan for shared parenting, close quote. Other examples showing this relationship are addressed in my merit brief on page 18. Also, if we look at the subsection that addresses the contents of a shared parenting plan, we can see that residential parent and legal custodian status is not to be addressed in a shared parenting plan. Subsection G addresses the contents of a shared parenting plan. It mentions 5 specific terms that must be addressed in a shared parenting plan: living arrangements, child support, medical and dental care, school placement, and holiday and special days treatment. However, this subsection does not mention residential parent and legal custodian status. If the legislature intended for residential parent and legal custodian status to be addressed in a shared parenting plan, it could have easily said so in this provision. It did not. This omission shows the legislature's intent that residential parent and legal custodian status should not be addressed in a shared parenting plan. In my remaining time, I'd like to turn for a moment to arguments 3 and 4 from our merit brief. These basically look at policy results should the court hold that E2B allows modification of residential parent and legal custodian status.
Let me interrupt you at that point, Mr. Dougherty. You've used the term modification.
Yes, Your Honor.
Was there a termination by the trial court, or did the trial court use the word terminate in its order with respect to the shared parenting plan?
That's a wonderful and complicated question.
Well, thanks.
When the trial court issued its order, it stated that it was making the mother the sole residential parent and legal custodian. But at the same time, it also said, however, all of our other provisions shall remain in effect. And there was an underlying shared parenting plan here. When the case went up to the Court of Appeals, the Court of Appeals said the trial court may have thought that it terminated a shared parenting plan, but by virtue of its actions, it did not.
Well,
it only modified.
The trial court thought it terminated the shared parenting plan, or at
Yes,
least
Your
it
Honor.
said it did. And the Court of Appeals said, well, you may have thought you did, but you didn't. You just modified it.
Yes, Your Honor, that's exactly right.
Okay, now can you highlight for my benefit why that becomes relevant to this argument?
I don't think it is.
Does the termination by the trial court change anything with respect to what you're arguing to us?
Not really, because the quote-unquote termination that the trial court did was to terminate the father's status as residential parent and to leave intact the mother's status as residential parent. But it did not terminate the plan in its entirety.
That's somewhat confusing. Could you explain in the mediation, in the order that came after the mediation for the shared parenting, I was under the impression that there was no designation as to status in the plan or in the trial court's order.
You're exactly right, Your Honor. There was not a specific designation. So what the law does, in accordance with subsection K6, it designates both parents.
So what the trial court was actually doing is not terminating, but actually designating to the mother the status in the last order. Does that make sense?
In large part, yes. I would agree that it designated the mother as the sole residential parent, but it did that by terminating the father's status as residential parent.